So thank you so much for getting up early in the morning to come talk about ethics. It's not the liveliest of topics always, but we'll try and change that today. I don't have all the answers, and I don't pretend to. This isn't going to be a prescriptive talk about what you should do or shouldn't do, but just to kind of give you some food for thought. So this quote. This will be the last slide with text. So we'll do what? All right. You can read it, but I'll read it to you as well. Ethical people often do more than they are required to do, and less than they are allowed to do. The law tells us what we can't do, prohibitions, and sometimes what we must do, mandates. It does not answer the bigger question: what should we do? And so that's kind of what it's kind of the frame. We're not going to get deep. This is not a lecture on, Plato or anything like that. But there are a lot of ethical challenges that face people in the creative sphere, and so let's talk about them. This will be fairly interactive. I'll ask questions. Please ask me questions. Please feel free to jump in if there's something that you're, question that you have, and I'll try and answer it while we're talking, and then, try and stop me afterwards. It's pretty easy, particularly at this time of day. All right. Law versus ethics. Parking ticket. It is illegal to park in certain places at certain times without paying the meter or whatever. But receiving a parking ticket, is that unethical? Have you done anything unethical, morally wrong? I just wanted to show old ladies hitting the bong. But same question. I mean, so marijuana use, except in limited circumstances, is against the law? Is it immoral? I don't know. I mean, you might have your own. Everyone has their own ethical code, right? Come on, work with me, people. It's early, but I respond well to my laugh lines at least. One of my favorite pictures right here. That guy has a moral compass.
What if there's two handicapped people in the car?
That is a fantastic question. And that goes to show that ethics are situational. Thank you for asking that. Your check is in the mail. But yeah, I mean, what is right in one situation would be wrong in another situation. So you can look at that and say, I think who is not appalled by that picture? I see two hands. I'm just kidding. Get out of here, you jerks. No, but I mean, we're all kind of shocked by that picture. But there could be a circumstance in which that were okay. So that is, that's kind of the lens through which, we look at ethics. They are situational. Another challenging one. People remember that guy? Dr. Jack Kevorkian, the suicide doctor, assisted suicide, big in the 90s. So another really tricky ethical question. If someone is in pain, can they choose to end their life with the help of this person? Well, the law says no, but there might be situations in which we would say, yes, we're comfortable with that. Make that choice. And again, this is just looking for slides for this was the best part of preparing for this. This one I like. I don't think she's putting the ring on. So again, is it against the law? Some states yes, and some states no. Is it immoral? Unethical? You guys are so progressive. All right, let's get into the meat a little bit. Hey, who's that? The fat Jew. I was unfamiliar with the fat Jew until recently. I only work with slim Jews. My two Jewish business partners are in the front row. So So why has the fat Jew been in the news recently? Stealing jokes. All right, which brings us to our first ethical topic. Using content without permission. Does anyone notice anything different about this slide than the previous slides? Yes, sir, Tim.
You credit it in the lower corner.
Thank you, Tim. There is a credit on this slide. One of the big dilemmas is in the digital age, it is incredibly easy for us to take pictures, music, and to distort and manipulate them so they might be unrecognizable. That doesn't make it right. It's against the law. It violates copyright law, but it's also unethical. But we've in the digital age, we've gotten to a place where it's so easy. Like, it doesn't feel like you're committing a crime if you're sitting at your computer at work and taking things and doing things. One of the big myths that I would love to dispel, if anybody hasn't had it dispelled for them, is that attribution is enough. That's something I hear a lot from clients, from other attorneys, from people all the time who come in and say, well, yeah, I used the picture, but I gave attribution. Well, that isn't how copyright law works, and it might be how ethics works. I mean, if your ethical codes could say that you quote somebody and that's enough. Of course, that isn't sufficient under the law. Under the law, you need permission. So the images that I used for this presentation were all from Creative Commons, other than the first few that I'm going to argue are fair use under the education exemption. But and for the few of my former students who are here today, and thank you guys for coming. You heard enough about that. But I used this Urban Outfitters slide. Why did I use that? They like stealing. I'm the one on camera who has to say that. No, but they have actually been sued for copyright infringement for taking designs off the web or taking them from independent fashion designers and taking those designs and using them without permission. They have been sued and found liable, so I am not saying anything defamatory by saying so. It's legally established, but I did have to check that to make sure that they'd actually been found liable and that they hadn't just settled all those claims. But yeah, I mean, that is a huge issue facing creatives. Who has had their work stolen? Anyone have a picture taken off a website and used by someone else? And how'd that make you feel? Did you want to do something unethical to them? Fair enough. Yeah, it's a terrible feeling. This is for creatives, and most of you are creators. And you create your work, and you may or may not have the means to protect it. You may not have the time to protect it, but you've put your work out into the world, and to see somebody else use it and to make money off the sweat of your brow is a terrible feeling. So you should really think long and hard about whether you do that. You shouldn't do that. Don't do it. Or do it all the time and then come see me when you get sued. All right, a little bit more of a gray area. Next slide, I want to see a show of hands. Who has done this? I don't mean window wash. Only the people in the back have ever freelanced from their day jobs. Okay, a couple up here too. All right. Slow, sheepish. Does this strike a little bit close to home for people? So you have a day job. Someone is paying you for 40, 50, 60 hours a week of your time. Are you obligated to spend every minute working for them during that time, or are you able to do things for your own benefit at the same time? No. Shaking your head, no. You can't do any work on the side from your job. Are you an employer or an employee? You're shaking your head. Employee. Okay. So that's a strong statement. Anybody have a different feeling?
Your employer knows.
If your employer knows, then it's...
They say, go ahead.
Yeah, that's a very fair point. You may have an employer. So in the creative sphere, if you're a designer or a copywriter or anyone in the creative sphere, you might have a job where your employers know that you're going to be on the hustle. Or they might know that they're not paying you enough to live. Right? So, again, it's situational. So maybe the right answer is to discuss it with them. See if you can use their computer after work hours to see if you can use, materials that are otherwise going to be thrown away. What about rejected content? So you offer a client 3 proposals, they take 1, the other 2. What do you do with those? Can you use them for something else? So that's an absolute. I've definitely seen some master services agreements from big companies that say otherwise. But, again, it's not a black and white issue. And it's also something, on a bigger note, that you can negotiate for. You can choose, when you're negotiating a master services agreement, to illustrate what you intend to do with the content that you produce. If they reject it, and it's a topic for another day, but that's something I often suggest to people, is that the agency or the designer retain the rights to rejected work. I mean, why not? You created it. Why can't you make some money off of it? Goes to the next idea. Who owns an idea? How many people out here have an employment contract? So a relatively small number have an employment contract. We live in Minnesota, we have, most employees are at will. They don't have an employment contract. You can get hired or fired, or you can get fired at any time for any reason or no reason at all, and you don't have a contract. A contract gives you some benefits, some guarantees that you have a job for a particular period of time, and that you are able to kind of rest in the safety of that contract. And if they let you go, they have to pay you off. But oftentimes an employment contract, it will say things like, all ideas that you create while you're under this employment contract are the property of our company. Anybody have a provision like that? Is that fair? Is it ethical? I think there's a story that Paul McCartney woke up one morning with the melody to Yesterday in his head. So who's woken up with a really good idea? I mean, Yesterday's probably the worst Beatles song, can we agree? But yeah, so, I mean, you wake up with an idea, you are not on the clock, you are not at work, you have not had your coffee yet. Should that idea, should your sleeping state, should your dreams be the property of your employer? All right, well, put it in your contract. All right, I'm just going to do one of these a little bit on the next slide, because I'm not the moral arbiter. I'm just a person bringing issues to the front. But who's been on either side of this equation? Yeah, more hands there. The exploited masses. Yeah, so you guys are all in creative fields. It's very often that you will go to school, study to do this stuff, or not study to do this stuff, and just have a talent. And you want to break in. How do you break in? You want to build relationships, right? You want to build a portfolio. So one way to do that is that you go and knock on one of the myriad agencies that we have in town, and they say, yeah, you can hang around for a while. And when you show yourself to do good work, they say, thank you for that good work. Oh, your internship is up. You haven't received any payment for that. We're not hiring right now, but we'll get back to you. Was that a fair exchange? I don't know. Maybe it was. Maybe you do great work and they say, we want to hire you. And then you've done a calculus that says, yeah, that makes sense. But if they had no intention of hiring you, if they are, there are laws around this stuff. There are a lot of laws around this stuff. Basically what the law is that you are not able, an internship is someone's educational opportunity, and you are not allowed under the law to have someone do work for you for free that you would otherwise pay someone for. So who as an intern has ever made the coffee? When I had internships, I had to make the coffee. I lived in a less enlightened age when dinosaurs roamed the earth. But yeah, you did all the menial tasks. That was what they did. We'd rather not pay someone to do the menial tasks. But under the law, you're supposed to do otherwise. But, I don't know the answer to this. Has anyone ever had an intern that they didn't pay? I know, it's like, oof, shoot arrows at me now? You crucify me? Using proprietary information, this one is, I think, a little, it's a tough one. Because who has changed jobs in the last 2 years? Most of the people here. So creative types change jobs quite a bit. There's a lot of movement between agencies in town, for instance, correct? Right? So the reason that your new employer hires you is because you are experienced and knowledgeable. That's one of the reasons, right? Talented, but experienced and knowledgeable. You know the game, you know the players. Has anyone been in a position where they were retained by a new employer to court a client that they swarmed there? All right, so at least one hand, a couple hands. So you have probably, now your employer has probably signed a confidentiality provision in their master services agreement. When a client takes them on, there is very often a confidentiality provision. Now, whether that trickles down to you or not, it's hard to say. And some employers are better about telling their employees about it than others, but they have signed an agreement usually that prohibits them from using that information for the benefit of anyone else. But if you are an expert in Windows, because you've worked on multiple Windows campaigns, and a new client brings you over, yeah, I'm looking at you. I know who your clients are. That information could be very valuable to a new employer. Should you use it? Crickets. Contract probably says you shouldn't, and you probably shouldn't. But, and even a new employer is going to say, well, don't tell me anything you can't tell me, but tell me everything. This happens all the time. And finally, crowdsource campaigns. Who has run a crowdsource funding campaign? Anyone? A few people? So a couple things here, a couple of ethical issues. One is, how do you set your goal for a crowdsource funding campaign? I've had a couple of clients say things to me like, well, I set my goal at what my mortgage is for a year. Is that ethical? I don't know if it is or not. If they're basically saying, fund my living so I can be this creative person, is that right or wrong? I don't know. The other issue that I think is worth pointing out here is just the idea of fulfillment. Has anyone ever supported a crowdsource funding campaign and not gotten the reward they signed up for? Yeah. Who are these jerks? Just send me my damn clock made on driftwood. Yeah, you know who you are. All right. So with that, I will turn it over to questions. My parting thought is just act consciously. Think about what you're doing. Think about what what the ethical implications are, and act accordingly. Thank you guys for coming out.
So gray areas often bring up more questions than answers. You brought up a lot of things for us to think about. I'm hoping you guys have some more questions for him right now. I'm going to get the microphone over here. If anyone has a question, raise your hand. We'll get you the microphone. Stump a Lawyer time starts now. Starting over here.
What is the deal with pants? I often tell my students that I teach in order to practice my stand-up routine. So that's what this will be. Go ahead.
Hi. Regarding the employer-employee brain trust, that if your ideas, it became a little gray for me when you said in the shower or off the clock. But it's a combination of rejected ideas or ideas that you've come up with on your time. If you're thinking of strategy or creative ideas that you haven't put down on paper. Okay, so not art, not photographs. Is that called intellectual property? And can you, if they present you with a contract, can you, as the person who's going to be working for them, ask for a line of clarification without having to hire your own attorney and pay for that?
I'll take the seventh part first.
Okay.
Great question. Fantastic question. So intellectual property basically what we're talking about in this case are things that are copyrightable and trademarkable. So there are no copyrights or trademarks in ideas. The intellectual property protection is in the tangible manifestation of such things. So an idea you have in the shower, if you don't put it on paper, how is anyone ever going to know? So, I mean, the way that this often comes up is in the context of, I quit my job and the next day I launch my new company, which does ABC, right? And then my employer comes back and says, well, you couldn't have just thought of it then, so actually I have an I have an interest in your idea. And this does happen from time to time, and I don't know how successful, a suit for something like that would be, but it does happen from time to time. But I think that, this is a point to make about clarity in contracts. Draft for what you mean. Put in your contract exactly what it is that your expectation is. You don't want to play gotcha with contracts. You want to come up with a contract that both parties understand exactly what they're obligated to do, and it's easy for them to do it. You want to make it easy for people to understand. You don't want to sue somebody. And as an employee, you don't want to be sued. You want to make sure you're in the right and that you have the rights to do what you've decided to do. So, yeah, I mean, and if you are presented with a contract, my students know the word I'm not going to use. But when someone hands you a contract, you should ask yourself, how am I being screwed? I usually use a stronger word. Because a contract, and it's not that anyone is out to get you, but people write a contract for their own benefit. They do not write it for yours. And so if someone hands you a contract, it is imperative that you have somebody look at it. And I do not like lawyers, except Dave. But I generally avoid them, but they provide an essential service. And if you are asked to do something that is going to limit your rights or give your rights to someone else, then you ought to know what you're signing. And I think it is money well spent. It is not a cost, it is an investment to have an attorney look at an agreement for you.
Right, I just meant, do you think that if it's a boilerplate contract and everybody in the room, I just wanted to know if it was standard procedure, if employers are aware of it, can you come back with that contract after having looked at it with a lawyer and add a sentence to their contract?
You can do anything with the contract, and you should. If a provision isn't clear, you should make it more clear. And boilerplate contracts are often not clear at all because they're trying to be applicable to myriad circumstances, and they might not capture exactly what you're trying to do. So I think it's, the thing about contracts is they're about power, right? The employer hands you the contract, and as an employee, you can take some of that power back by asking for clarity, by trying to get a definition, to saying, can we limit it to this? And I think that an employer, they might think you're a pain, but I think they will respect you for doing it, and it'll make your relationship with them better.
So they kind of do respect it. I mean, I've done it where I've taken them crossed out.
Yep.
Initialed it, had them initial it.
Yep. Redlining a contract is a perfectly legitimate way to do it. Cross it out, initial it. I mean, the best way to do it is to get a clean copy that is very clear about what everybody's expectations are. But people do who's ever purchased a car? I love it. I love buying cars now that I'm an attorney. Because you hand them a business card and they go, oh, crap. But yeah, I mean, we mark, my law partner Dave and I have talked about it multiple times. You go in and you just mark everything up and they don't know. That's a salesperson. It's good to have the power. Yeah,
Hey, Blake.
good morning.
So I could have a million questions for you, but I'm going to narrow it down to one. I want to talk about social media.
Ooh.
Yeah. In relationship to, say, I work for a company and they have a social media account. As a graphic designer, the background I've kind of been taught is that you should create your own original content. The Urban Outfitters example is great. Can you talk a little bit of how that extends to social media? Because that seems to be a huge gray realm of reposting and memes and stuff, and just...
Is my head still here or has it exploded?
It might have exploded, but I hope you can gather a few thoughts together and just help us out a bit.
Sure. So the Copyright Act that we currently live under was enacted in 1970, the Copyright Act of 1976, effective as of 1978. Who was tweeting in 1978? One guy. The futurist in the room. So yeah, it's a real challenge. New media creates new things, and memes absolutely are someone else's property that we take and manipulate, put some clever text with, and use and reuse, and we retweet, which at its core violates the copyright of the individual. Now Twitter has terms of service that say you are granting a license to people to reuse your content. But when it comes to memes particularly, I mean, memes are absolutely a copyright violation. There is no fair use exemption for them, but they are a massive part of everyday life now. And our copyright laws have not caught up with where we are as a society and the way that we communicate with one another. But you should create your own content. And maybe, what if you come up with something really clever that is going to work really, really well with a Garfield comic strip? Nothing works well with Garfield. The only thing worse than Garfield is Heathcliff. Can I digress? No. The poor man's Garfield. Look it up. But yeah, so if you really had this great idea that went with this strip, why not reach out to the creator and seek permission? You know, I mean, the problem is, like with, taking a still from Office Space or something, are you going to reach out to whichever studio put that out, or Mike Judge, or whoever has the rights to that? Are they going to get back to you? Do they have time to grant you a license for your meme? Probably not. But, I mean, in the strictest sense, under the law and ethically, you should get permission for the things that you use, or you should create your own original content. But gray area. Yes?
On that social media track, as an individual floating around on the internet, I have done a bunch of stuff that I could defend by saying, oh, it's transformative use. Can you do that as a business with social media, or can you only get away with that as, like, the little girl in the corner of the internet?
This is why lawyers make the big bucks. That's a very difficult question. The real answer, the brass tacks answer, is that the reason that people get away with so much stuff as an individual is that no one is going to take the time to sue you, practically. This is not the legal answer, this is the real answer. Is that you do not have, I mean, people could come after you, if they have registered a copyright, they could potentially sue you for damages of, they can sue you for attorney's fees, and they can sue you for damages of up to $150,000 per incidence of infringement. If someone was going to go through and track down every meme maker, every person who was using content somewhere on the internet that didn't belong to them, I mean, you could make trillions of dollars. Of course, those, you don't have the $150,000 to pay. I don't, maybe if you do, we need to talk. Yeah, I mean, you don't have the money on hand to pay that out. And the attorneys for the people know that you don't have the time to do that, or the resources to do that. So probably the most that's going to happen if they can track you down is they'll send you a cease and desist letter. A company, on the other hand, is going to have deeper pockets and should know better. I mean, most of the people who steal your content if you put a picture on your blog and somebody takes it, most of those people are kind of ill-informed, or uninformed. They just don't know, or they don't care. But they are not, most of it isn't malicious. It's just become so easy. I mean, I teach, my students are all in their late teens, early 20s, and so they grew up in an age where, you just, stealing music was how you found music. And, for me, who used to go to the record store with my paper route money and spend all my money there, like, I grew up in a different time. But it's, if you grew up thinking it's so easy, and if you're a kid now, if you're a 13-year-old getting into social media now, why would you know any different? And I would say it's probably incumbent on people to teach their kids, what is right and wrong, what is ethical and what is unethical. But yeah, that's the reality, is that, people are only going to sue somebody with deep enough pockets to pay them. Otherwise, it's not worth it. Yes, sir.
To return to the Urban Outfitters example for a second, understanding that every situation is different, if as an independent creative person, you feel like something that you created has been appropriated by either another individual or corporation, how would you suggest people proceed
That's a great question. How do you proceed when somebody steals your stuff? When it's a company, when it's somebody who has those deep pockets that we're talking about. So this is a little bit tricky because you have more rights to go after somebody if you have registered a copyright in your work. If you have registered a copyright in a work, then you are able to go after somebody for attorney's fees, and you are able to go after somebody for statutory damages, that $150,000 up to $150,000 per incidence of infringement. If you have not, then you can only get injunctive relief. You can make them stop. You might be able to make them pay you any money that they have earned off your intellectual property, but you cannot get those statutory damages, and you cannot get attorney's fees. And let me tell you, attorneys ain't cheap. So it is, it's, I would say as a creator, get to know the copyright system. It is not too difficult. I mean, like I often tell my clients, like that's something you can probably do yourself, register your own copyrights. And if you're a photographer or a designer, you might register your designs or photos a month at a time, quarterly, and you can do it for $55. And it is money well spent to have those designs protected because the designs have to be protected before they were infringed in order for you to have that right. So very often people come in and say, hey, I just got, someone stole my picture, can I copyright it so we can sue them? And no, we can't. I mean, we can sue them, but you have to pay me rather than getting your attorney's fees covered by the other side. Yeah?
Talking about the transformation of images that you don't own on the internet.
Yep.
Is there a base level of distortion on, like, for example, with Richard Prince?
Mm-hmm.
He repurposes Instagram photos and makes hundreds of thousands of dollars off of that, but he's doing it in the purpose of art. So is there a basic level of distortion and now it's your content that you put through filters, you've done different types of manipulation of an image?
Gray area. There is no bright line rule on that. None at all. And, and I would say that the smart play at any level, I mean, because all it takes is some, somebody who is actually, here's the issue. Has anyone registered the copyright in their Instagram image to begin with? If they haven't, then they have foreclosed their ability to go after certain types of damages, and it may not make economic sense for them to pursue someone for using their photo, even, to get to a point where we're determining whether the use is transformative or not. So, yeah, it's a dangerous game. And, we live in an age where that stuff is so easy to do that it's becoming more and more prevalent, and I think there's not a clear answer to it. Yeah?
So it was more with the copyright. As a photographer, do I have to copyright every single image when I have thousands of images every month?
So what I usually suggest is that you do what's called a compendium copyright, which means that you register a copyright in, let's say, your images for every month. You just put them in a contact sheet, like a book, and you register all those. You might register the February 2016 images. You might do that every month. And there can be thousands. There are just no limit to the number that you can include in a compendium copyright. But in order to do it on a kind of regular basis, to make sure you have protection for every image that you have, it makes sense to do so.
Obviously, that doesn't count for like work for hire, where they have
Correct.
full rights and usage. And
Yep. Work for hire agreements mean that the person who is paying you has all rights to it, and then it would be their right to go after somebody for infringement, not yours. Yeah.
What about using people's words? So like products that have quotes on them.
Mm-hmm.
On a copy on a print. If it's a quote that's somewhat well known and super traceable, that seems more clear cut. But what about when it's something you've heard on a podcast or just some phrase that you've seen being thrown around by creatives a whole bunch, but nobody really knows where it came from? How can you protect yourself and know that you've gone through the right steps to get that chunk of words licensed free from?
I'm going to go in there and hide. It's a really difficult question, right? I mean, like the baseline is if it's someone else's property, you should get their permission to use it. But there are a lot of quotes. The one that I've seen attributed to like 100 different people is like that quote that writing about music is like dancing about architecture. Like I've seen it quoted at Miles Davis and Frank Zappa and all these different people, and no one really knows who first said it, or at least I don't know who first said it. But can I slap that on a T-shirt and sell that T-shirt? I mean, like I think the ethical answer is I should try and get the permission of whoever the creator was. But if I don't know who the creator was, and the other thing is that at some point, this stuff will all enter the public domain. The term of copyright in the United States right now is life plus 70. So anything Mark Twain said, you can put on a T-shirt and not tell any or not pay anyone, right? It's like if you go to Barnes and Noble and you want to like look sophisticated, you want to buy the classics that are in the front, that are like $4 a piece for the faux leather-bound editions of famous novels. They can print those because they're in the public domain. Moby Dick and Mark Twain's novels and Jules Verne and all those things that predate that the copyright is expired on. Anyone can use those for any purpose. And this goes back to the impetus behind copyright law was to protect creators, but only for a limited period of time. And that period of time started out in Britain as 12 years. And now it's life plus 70. So, we've obviously decided that not only the creators should be protected, but their great-great-great-grandchildren. Yeah,
Wait,
back.
we have a question over here.
Okay, go ahead.
Can you talk about common law copyright? That is, if you have a name of something and you just put a copyright behind it on your own.
Okay, so when the Copyright Act of 1976 came into effect, the copyright changed. You do not have to register in order to have copyright rights. As soon as you have taken something that is a creative idea and fixed it in a tangible medium, you have copyright protection. And you can put that copyright symbol on or not. You can't use the R, the registered, unless you have registered. And that's usually for trademarks anyway. But you have rights in something as soon as you've created it. And you could sue someone and make them stop using what you are using based on that. But unless you register your copyright with the Copyright Office, you cannot sue them for those statutory damages. But there is no common law copyright in the United States now after that act because you have those rights upon creation. In the back? Please. Sorry to hear it.
Someone who is managing unpaid interns, and it's now become a really big soapbox for me to help make sure that those who go into internships know how they're protected.
Doing God's work.
I would love,
Okay.
I do what I can. I would love to just know some kind of go-to defenses for that so that they can go into those negotiations knowing how and why they're protected so that they don't get screwed over.
What go-to defenses for interns?
Yeah, so when they get offered an internship, knowing what their rights are, knowing what they can push back on, and saying what's unethical and what's illegal for them to be asked to do.
All right, well, so a couple things. If they're student interns and they're getting college credit for it, for instance, that is a place where you can use your school. Make the school the bully. Because there is a definite power disparity between an employer and an intern. As an intern, you feel kind of lucky to be there. And, so you are not going to rock the boat a great deal. But maybe your school can. Maybe somebody can call in and say, okay, why is my student making the coffee? They're there to learn how to be a designer, how to be a copywriter, whatever. So they're there for a purpose. Do your duties fit that purpose, the purpose of the internship? And probably the best defense is to outline from the outset, what are the expectations for interns? What am I going to be doing? Who am I going to be shadowing? And, as we know, in the creative world, it's an all hands on deck, kind of operation. And the most senior people might be making the coffee sometimes. But it's got to be done because we're going to pull a late night here and it's all hands on deck. So it is a fast-paced world. But I think that setting the expectations and not being afraid to say, okay, my understanding of my role was this, and now you're asking me to do that. But, you do it advisedly. I mean, you don't want to piss somebody off when they're crazy busy and they're asking for your help. But that is your real protection, is to outline that early, get it in writing. It's always the best. Identify how many hours am I supposed to be here, what duties am I supposed to have. Yeah. Yeah. Yeah, I mean, it's, and like I took an ethics course in college,
and it was, like it was about Plato, and I don't remember any of it. And I teach, it's funny, I teach one of my students from that I teach grad school. I teach arts, law, and ethics at St. Mary's. And Katie, how long did we spend on ethics? It was a lot of time. It was like a half an hour. It was a lot like this. It's basically like, you were looking at things, and it's subjective and it is situational. So you need to, and it's adapting and changing all the time. So, it's basically like, do you have a moral compass or not? And, do you follow that? So, yeah, but yeah, it isn't a common thing for people to take a class on it. Yeah. Uh-oh. Get it in writing. Yeah, I know what you mean. So my brother's a physician, and physicians have this long tradition. Anybody a doctor in here? Thank God. Yeah, I was like, what are you doing here? But in medicine, you go through your residency and they work you 100 hours a week and they pay you nothing. And some of the justification, if you talk to older doctors, they will say, well, I went through it, so you have to. And the creative field is a lot like that, right? Everyone starts out on the bottom and kind of finds their way up. But, in order to be right, again, what the law is about internships, and it's, I'll try and boil it down. It's a little bit complicated to answer in this forum. But you are not able to have someone do anything that you would pay someone for free. So it is a tricky thing. Now, if they're getting a learning experience in college credit, then things are off because they are receiving consideration. They are receiving college credit. And one could argue that they're receiving consideration in their experience. But the law really frowns on this. And basically what happens is the Labor Department kind of makes an example of a company every couple of years. A big company that, if you're an intern at Goldman Sachs or something, you could afford to pay your people. And if they don't, and they have people doing things that they would otherwise be paying people to do, the government can make an example of them. The reality of it is a little bit of a devil's bargain. You are a small organization, you're trying to get help, you're trying to grow your practice, and you are using that, you're exploiting somebody's talent, and in theory they are getting something out of it. But it is tough to be a small business. It is tough to have the resources to pay the people that you would want to pay. My law partner and I have this conversation all the time. My artist management partner and I have this conversation. It's like we would love to pay people and to pay them more, but we're just a small business, and we don't have the means to do so. We have always been trying to grow to get to that place. But, so you try and figure out ways to give people something that makes it worth their while. Well, thank you very much for coming out. I really appreciate it. I'll take questions outside if anybody has them.